Thank you very much, Richard and Joan, for those very kind words of introduction. I'm feeling slightly overwhelmed after hearing that. So thank you, and thank you all for being here tonight, both in person and to my colleagues who have joined online. It's lovely to see you all, and I feel very honoured. I want to say thank you particularly to everyone who's been involved in organising tonight's lecture. So that includes Luke Moffat, Cheryl Lothar, Declan Coyle and Richard Somerville from the School of Law, and Wendy Louise Smith and Brett Walker from the Mitchell Institute. So as Richard mentioned, my lecture tonight is on a book that I'm in the middle of writing at the moment. And this book examines the legality of amnesties. So when I talk about amnesties, what I mean are legal and policy measures that at a minimum remove criminal liability for wrongdoing prior to conviction. And as the book's title suggests, what this book is asking is does customary international law prohibit amnesties? And this question arises particularly when we think about international crimes. So that is war crimes, genocide, crimes against humanity, and serious violations of human rights in some people's interpretation of that term. In many ways, I think this is an ideal subject for my inaugural lecture at Queen's, because my fascination with amnesties began here when I was a master's student and I was in Tom Haddon's conflict regulation and conflict resolution classes. That's when I first started thinking about it, and it became my master's dissertation in that course, and then it became my PhD research. And it was through those studies while I was here that I started developing a database of all the amnesty laws I could find in the world that were enacted after 1945. So by the time I finished my PhD, that database had about 500 amnesties in it. Now the full database has about 700 amnesties that were granted from 1945 until the end of last year. So after my PhD at Queen's, I kept working intermittently on amnesties alongside other research projects. And I think one project that's perhaps particularly relevant for tonight's talk was the Belfast Guidelines on Amnesty and Accountability. On that project, Tom Haddon and I had the great privilege of leading a team of multidisciplinary experts from around the world, some of whom I think are attending online tonight, so hello. And we worked together to produce guidelines to design legal, to inform states in thinking about how to design legal and legitimate amnesties. To inform the expert group's deliberations on that project, in 2012, I wrote a 97,000-word report that set out the underpinning evidence to support what was going into our guidelines. We didn't publish that report, but I think the process of working on it, the process of gathering that evidence and the debates we had on it among the expert group and the encouragement I had received from some of the members of that group to publish it as a book really are the origins of what I'm exploring today. This book is also made possible by my involvement in the Peace Threat project led by the University of Edinburgh and funded by the FCDO. Being part of the Peace Threat project has provided me with the resources and technical support from my wonderful colleagues in Edinburgh to publish a subset of my amnesties data relating to conflict and peace, which you can see on the slide there. So that was first published in 2020, and in the last year, I worked with a postdoctoral researcher, Dr. Daniel Shaw, who updated the database for me, and so we published that a few months ago. This database provides one strand of the empirical data I'm going to show you tonight, and alongside, I'll show you some of the emerging findings coming from it. So before I do, one thing I want to acknowledge is this book's had a long germination. It's going back to a report I wrote in 2012. And I think the fact that I'm only really getting to it now speaks to how hard it can be to write books alongside the other pressures of academic and family life. So I'm very grateful that over the past year, I've benefited from a British Academy mid-career fellowship that's given me more space to develop that, as well as the FCDO funding. I'm also very grateful to my colleagues in the School of Law and the Mitchell Institute, many of whom are here tonight. As everybody in this room knows, but perhaps people joining online don't, Northern Ireland and Queen's in particular really are wonderful places to study how societies overcome histories of violent conflict. And I feel very lucky to be part of a rich interdisciplinary research environment and to have very generous colleagues who are always willing to give up their time and to share their thoughts on my work as it's evolving. I also want to acknowledge that some of the ideas I'm exploring in this book have been greatly benefited from the profound wisdom of my colleagues on the Institute for Integrated Transitions Law and Peace Practice Group, who collectively have a wealth of experiences on the practical challenges of balancing peace and accountability in different parts of the world. So, as a result, while I'm presenting research tonight that is a sole-authored book, I think that like most academic work, it's very much shaped by the people I work with, the context I work on, and the projects and experiences I've been involved in over the years. So in the years since I wrote the Belfast Guidelines report, my vision for the book has shifted considerably. In that report, I was trying to map out all the legal frameworks relating to the legality of amnesties. Tonight, I'm focusing much more on their legality in relation to customary international law. And I think this shift was inspired primarily by observing that international human rights bodies and international criminal courts have made pronouncements that were at odds in different ways with the idea that there is an established customary international law rule that prohibits amnesties for international crimes. So I'll show you examples of what I'm talking about in a few minutes, but I think before I do, it's useful just to say a few words about how do we know if something's a customary international law rule. Some order before I get to the more technical stuff. So there are two main theories that you see talked about in academic literature on how do we identify a customary international law rule. The first one is known as positivism. And positivist approaches are really grounded in the principle of state consent. So what this means is there's a vision of international law as being something that's created by states, and according to which states are only bound by international obligations which they've consented to be bound by. The basis for positivism can be found in Article 38 of the Statute of International Court of Justice, which is regarded as the most authoritative statement of the sources of international law. Article 38 of the statute states that the primary sources of international law are treaties, customary international law, and general principles. In addition, this statute sets out two elements of how we identify customary international law. Those are state practice and opinio juris. So what states, you're looking at whether states are engaging in particular practice because they believe they have a legal obligation to do so. So you need both elements as evidence of customary law. The International Court of Justice has repeatedly emphasized this two-element approach in its case law. And in doing so, it said that for a rule of customary law to exist, state practice must be extensive and virtually uniform, or in general must be consistent with such rules. So this approach suggests that if we want to know if there's a rule of customary international law, we had to observe what states are doing and what they're saying about the law. And we have to determine if there's sufficient evidence to say that most states are supportive of willing to be bound by the purported rule. The International Law Commission endorsed the positive method in their 2018 draft conclusions on the identification of customary international law. In its reports leading up to those draft conclusions, the International Law Commission said that this is the only method of determining customary international law that has widespread support from states. However, I think there's a really interesting growing literature on legal interpretation in international courts. And some of the scholars writing in that field have found that international human rights courts and international criminal courts do not always routinely apply positivist methods when they're looking at customary international law. Instead, they argue that they apply more deductive approaches, which academics generally term modern approaches. So modern approaches are defined in lots of different ways in the academic literature, but in general terms, they're distinguished from positivist methods because they tend to give much less weight or hardly any weight to what states are doing. Instead, they tend to identify legal rules deductively from written texts. So there's a lot of weight placed on looking at international treaties. Then there will also be weight given to looking at international case law. So you see a lot of courts citing each other's judgments. Then there will also be reliance on views of the law pronounced in UN General Assembly resolutions or in UN reports by the International Committee of the Red Cross, for example. At times, the scholars say that modern approaches to international law supplement this legal analysis with arguments about the political, moral, social consequences of particular decisions that they're taking. So these two different methodological approaches were in my mind as I started reading through international case law and amnesties. So in a chapter in my book, I go through lots of different decisions before the different regional human rights courts, as well as in some of the international criminal courts that have issued opinions on amnesties. And I also look at some of the UN reports as well, where they've set out what their view on what the legality of amnesties is. And I think what I found is that almost uniformly, those decisions apply modern approaches to international law. So what I mean by that is you see very, very little reference to state practice when you're looking through that case law. What you see instead is a lot of deductive reasoning where courts are citing each other's opinions on the legality of amnesties. And you see references to UN General Assembly resolutions and the other sources that I mentioned. These decisions also often make assertions about the consequences of amnesties, talking about the fact that they will lead to impunity or they will lead to a return to armed conflict, for example. Often those assertions are made without supporting evidence. But most instances, these courts, using these deductive forms of analysis, have found that either a rule of customary international law exists that prohibits amnesties, or such a rule is in the process of emerging within international law. However, I think a few courts have been a bit more tentative in their determinations. And I'll demonstrate these different interpretations. I'm going to show you some of the claims that are made about this customary duty existing, and then I'll show you some of the ones which are made that question it in different ways. So on the first slide here, I've taken 3 commonly cited positions on the legality of amnesties. The first one comes from the International Committee of the Red Cross's 2005 study on customary international humanitarian law. And in this study, the International Committee of the Red Cross set out a new rule saying that customary international law meant that amnesties could not apply to persons suspected, accused of, or convicted of war crimes. Then, a few years later, the Office of the High Commission for Human Rights at the United Nations published a report on amnesties, where it set out its vision of what the legality of amnesties was. This came after a number of years where the UN policy had moved away from endorsing amnesties to saying UN mediators could no longer sign off on peace agreements containing amnesties, but this was one of their first expressions of saying that amnesties were impermissible under customary international law. And so I've quoted one passage from the report there that says, under the various sources of international law and UN policies, amnesties are impermissible if they prevent prosecutions of genocide, war crimes, crimes against humanity, serious human rights violations. And so I read that as a reference to customary international law because they're referring to various sources of international law, and also because they're referring to crimes against humanity. At present, there's no international treaty that creates state obligations for crimes against humanity, so those obligations have to be found in customary international law. The third quote you can see there comes from a report by Amnesty International. This is a report that was used by Amnesty to advocate for the inclusion of articles prohibiting amnesties in the treaty that's being developed for crimes against humanity. So you can see there, they're saying clearly that their view is a rule of customary international law has now crystallised prohibiting amnesties for international crimes. So if we turn now to looking at more divergent opinions, I think one of the strongest challenges to these assertions that customary international law already prohibits amnesties for international crimes came in a judgment by the International Criminal Court in the Gaddafi case in 2020. As you can see on the slide there, the appeals chamber of the ICC said that international law is still in the developmental stage on the question of the acceptability of amnesties. Other jurists have accepted in general that international law should restrict the use of amnesties, but have questioned its applicability to particular settings or to particular forms of amnesties. So one case I find particularly interesting in this respect comes from the Inter-American Court of Human Rights. So many of you will know the Inter-American Court of Human Rights has really been at the vanguard of developing international law to restrict amnesties and has a strong and robust case law to that effect. But that case law has by and large come from unconditional amnesties granted to deal with the legacy of military dictatorships in South America. The court didn't really have much opportunity to think about amnesties coming from conflict until the El Mozote case, which related to a peace agreement, an amnesty that was part of ending the civil war in El Salvador. In this case, the main judgment found that the amnesty violated the state's obligations under the American Convention on Human Rights. However, in a concurring opinion, the president of the court and 4 other judges raised the possibility that amnesties may sometimes be necessary to ensure the right to peace. In the quote you can see on the slide, they suggested that when evaluating amnesties that come from negotiated peace agreements, they should not be automatically rejected. Instead, they should be considered in light of criteria that recognize the complexity of trying to balance the need for peace with the pursuit of accountability. In addition, the African Commission on Human and People's Rights has indicated its view that blanket and unconditional amnesties that prevent investigations of serious violations are impermissible. However, they left open the possibility that conditional amnesties are permissible, even for serious violations. And that's something you see then reflected in the views of some African courts, African states when they're talking about amnesties, and also in the African Union's transitional justice policy. So when I say conditional amnesties, what I mean is where an amnesty is granted on the basis that an individual has to comply with certain conditions in order to receive an amnesty or in order to retain it over the longer period. Often conditions relate to trying to reduce the violence within a society. So they can be requirements that individuals surrender, disarm, reintegrate, renounce violence, and refrain from re-engaging in violent offences. Less common, but still has happened on several occasions, amnesties are conditional on individuals complying with certain measures to try and fulfill victims' rights to truth, justice, and reparations. So this could be where individual offenders have had to tell information about their past crimes. It can also be where they've had to acknowledge the harm that they've caused, where they've had to engage in community service or apologize or make other forms of material or symbolic reparation. So for me, these judicial opinions suggest that the idea that there is a customary international law that prohibits amnesties for serious violations in all instances remain uncertain. There's some ambiguity around this, looking at the different patterns of case law. And I think this is interesting for me, and I think it's significant for international law for a number of reasons and for peace building. So I'll explain why I think these questions matter first. So I've mentioned that, at the level of the International Law Commission and largely in the views of states, positivist methods are regarded as the only method really for determining a customary international law. However, international courts and scholars have different opinions about that. And so that's why you see reflected in the judgments. And so legal academics are quite divided over the relative merits of positivist and modern approaches to international law. There's certainly a detailed and interesting body of literature where scholars argue that modern approaches can be valuable for determining the law in areas where practice is lacking, and for ensuring that normative standards are upheld and advanced even where they face resistance from states. And the literature would say this is particularly important when it comes to really pressing global issues like human rights and the protection of the environment. However, there's a number of other international legal scholars who are quite concerned about the consequences of modern approaches to international law. So these scholars emphasize that legal interpretations that do not analyze whether states have engaged in sufficient practice and opinio juris to create a rule of customary international law risk making incorrect assertions about what states' legal obligations are. And they suggest that these incorrect assertions risk setting out obligations that states are unwilling or unable to fulfill. Other concerns have been raised by scholars working in the area of third world approaches to international law, or TWEL. And these scholars have highlighted that a tendency to use forms of deductive reasoning tend to reflect global north visions of international law. They suggest that these outcomes often clash with understandings of international legal norms coming from the global south, particularly where there's been little consideration of state practice from the global south. And again, this could lead to assertions of legal rules that states do not recognize as being bound by. So there can be problems arising from that in and of itself. We want the law to be accurate and understood. We want states to be able to comply with the obligations that they're established. I think scholars also assert that where this happens, it can lead to challenges to the legitimacy of customary international law if it's seen as going too far beyond what states are willing to agree or able to comply with. So I think those are general concerns, not specifically about peace or conflict or about amnesties, but just about these methodologies within the literature. But I think if we think particularly about conflict resolution, these questions are also particularly important. And I think that's because assertions of whether there is a customary prohibition of amnesties already have real-world consequences on peace negotiations in numerous societies. International judicial opinions asserting the impermissibility of all forms of amnesty can restrict the space for states to balance pursuing accountability with the need for an inclusive peace settlement. This can happen when international courts intervene directly in countries where there are peace negotiations, or it can arise where intergovernmental organizations, mediators, or civil society activists rely on particular judicial decisions on amnesties to pressure states to refrain from certain forms of amnesty, and particularly where they do this without acknowledging that international judicial opinions aren't all uniform on this question and without acknowledging that state practice is mixed. And I think one other strand that I'm going to return to at the end of the lecture, that's significant, is that there's a growing body of literature coming from political science scholars that is measuring the impact of amnesties on peace. And by and large, it's finding that amnesties granted as part of a peace agreement can have a positive outcome on conflict-affected societies. So, turning now to my research design, I think it's probably clear from what I've said that what I'm interested in is state practice. Right? I'm looking at what states are doing and what they think are legal obligations. But that raises questions about, well, what do I mean? Where do I find evidence of what state practice is? And so to try and think about this, I've been looking obviously at the International Court of Justice decisions, the UN International Law Commission's conclusions on this matter, and also academic literature by legal scholars on the sources of international law. I've also been using writings by international relations scholars in norm theory, where they've been using social science methods to investigate the existence or robustness of international legal norms. And working through all that literature, I've decided to try and look at state practice in relation to what I'm calling 3 different sites. So the first one relates to what states say about amnesties in relation to proposals that international treaties restrict their ability to grant amnesties. I'm also looking at how states comply with the idea that amnesties are prohibited within their domestic law. And then, because there's an assumption that if something is an established customary international law rule, then if a state violates it, other states would object to that. They would respond in some way. I'm looking to see whether there are state responses to the enactment of amnesties for international crimes. And so the book is going to look at lots of different sources of data around this. I'm only going to be presenting some of it tonight because I don't want to keep you here all evening, but I'll work through some of those things. And as I'm working through the data, the questions that I'm asking of it is there evidence of sufficiently widespread state practice to say that this international legal rule exists? And also when I'm looking at the practice, I want to see if there's patterns within it. Are the voices that are advocating for the prohibition of international legal norms concentrated in particular world regions? Are they conflict-affected states or not? Do they have particular systems of governance? Because in the literature, there's a sense that perhaps some of these norms are advocated more by democratic states. And so these are different things I'm trying to tease out. I'm also making sure that my data includes this practice of states from the global south to address some of the concerns raised by trail scholars. So, turning now to the first bit of my data, this relates to how states have engaged with discussions that international treaties should in some way restrict or regulate their ability to grant amnesties for international crimes and serious violations. So I've identified all the treaties I could find where these types of proposals have been made by one or more states, and you can see the list of these treaties on the slide there. So there's 4 existing treaties and the one on crimes against humanity, which is in the middle of being developed at the moment. And I think the first point to mention when you look at this is that on every occasion where a treaty provision to restrict or regulate states' ability to grant amnesties has been proposed, it was unable to gain sufficient consensus among the negotiating states to be included within these treaties. So as a result, there's no international treaty that explicitly prohibits amnesties. And on the contrary, additional Protocol 2 that you see there is the only one that really talks about amnesties, and the language in that treaty encourages states to grant the broadest possible amnesty at the end of hostilities. The commentary to that article produced by the International Committee of the Red Cross said that it was intended to encourage reconciliation within societies that were divided by conflict. And it's interesting that that article was adopted by consensus by all 120 states that were part of those negotiations, and there's been no reservations entered in relation to it. I think if I look at the voices that were calling for the amnesty prohibition, for the two treaties that were agreed during the Cold War, the calls for the prohibition and amnesties came mostly from states that were either the USSR or somehow under the influence or aligned with the USSR. And I think that's interesting. So you're thinking about a very small group of states. They weren't able to persuade the rest of the states. But I think legal historians writing about those negotiations have suggested that some of those positions were reflective of global geopolitics at the time and the ideological points that were trying to be scored in those negotiations. But if I turn now to the negotiations throughout the 90s that led to the creation of the International Criminal Court, in those negotiations, there were several states that expressed the view that the amnesties should not bar the International Criminal Court from exercising jurisdiction over international crimes. But one of the delegates taking part in those negotiations, Darrell Robinson, reported that many of these states had misgivings about asserting that prosecutions are the only appropriate response in all instances. So where they expressed misgivings, they weren't always saying that there needs to be a line that amnesties need to be prohibited. In some instances, they were proposing that there were guidelines in the statute to guide the court to determine when they could intervene or when they could not. So there was a variety of different opinions there. But those views were also met by a number of other states that were quite resistant to the idea that there be any language within the Rome Statute. And in the end, the issue was so divisive that the Rome Statute was silent on the question. States were similarly divided during the negotiations leading to the Convention on Enforced Disappearances. Interestingly, in these negotiations, several compromise positions were put forward by states and the chair of the negotiations. These included suggesting that amnesties that could be granted for disappearances, provided that they were conditional on people contributing to truth and reparations. Or they suggested that the treaty could specify that amnesties could not prevent reparations or could not inhibit efforts to locate the remains of disappeared persons. However, even these compromise positions went too far for some states. And in the end, the convention was again adopted without any language on amnesties. And interestingly, only 3 countries, Cuba, Italy, and Canada, chose to put on their record that they would have preferred the convention to say that amnesties couldn't be granted for disappearances. So it was not a large number of states taking part in the negotiations that were willing to put those views on the record. These debates continue to play out in the work to develop the International Convention on the Crimes Against Humanity, with the result that the draft articles currently before the 6th Committee of the General Assembly make no reference to amnesty. And it's interesting that when those draft articles were shared by the International Law Commission with UN member states, only 4 states came back to say that there should be some sort of prohibition on amnesties in the convention. And one of those, Sierra Leone, said it should only be a prohibition on conditional amnesties. So again, you're seeing not many states coming forwards to advocate for this position. If they thought it was already a rule of customary international law, there's a sense that they would be more willing to see this reflected in a treaty. So if we think about the other side of these debates, across the decades when these treaties were negotiated, the language that states used to oppose the inclusion of language prohibiting amnesties was clustered really around 3 different arguments. The first was that amnesties are necessary for conflict resolution and for reconciliation. And those arguments have been made right throughout all those negotiations. The second is states asserting that granting amnesties is part of their own state discretion and as a matter that should be regulated by domestic law and shouldn't be regulated by international law. And then thirdly, and this is, I think, particularly common in the more recent treaty negotiations, several states argue that treaty provisions on amnesty should not be included because it would be impossible for states to reach a consensus on them. So then that's states expressing their view that states are very divided on these questions. The numbers of states making one or more of these arguments has consistently been greater than the few states that have advocated for treaty language prohibiting or restricting amnesties. In addition, the states that have resisted the inclusion of treaty prohibitions have tended to have considerable diversity in terms of world region, conflict status, and regime type. So this sustained lack of willingness to include these provisions in treaties among a diverse range of states is one strand of evidence I think gives us reason to question whether this customary international law rule exists. I'll move now to the second set of data that I'm interested in, and that relates to compliance at the level of domestic law. So if states had this obligation, there's a sense that they would be bringing their domestic law into alignment with it. So one of the first things I was looking at here are domestic legal rules that shape how executives or parliaments can grant amnesties. So I wanted to know, do these domestic rules restrict the crimes that can be covered by an amnesty? These rules are usually covered in constitutions, national penal codes, or criminal procedure codes. And I looked at all of these documents for over 192 states, and I found that 10 have restrictions on the use of amnesties for international crimes. You can see the 10 countries in question on the slide there. A further 11 had restrictions saying that amnesties could only be granted for political crimes, but I think there's a question on how you interpret political crimes and whether that extends to international crimes or not. But overall, I think that shows you that very few states have restricted the application of amnesties to international crimes within their domestic law, and those that have tend to be concentrated in South and Central America. The next data I've been looking at relates to peace agreements and the inclusion of amnesty provisions within them. Here I've used the PAX Peace Agreements database created by my colleagues in the Peace Rep team, and that database has information on 117 peace agreements that have amnesty provisions where the parties committed themselves to granting amnesty to combatant groups. So I've gone through those provisions and looked to see, do they have explicit language that says this amnesty cannot extend to international crimes, or do they not? And I found that only 29 of the 117 peace agreements had commitments that the amnesty could not extend to genocide, war crimes, or crimes against humanity. And these 29 agreements relate to only 16 countries, because 10 of them relate to the Democratic Republic of Congo. In addition, I think the chart shows you that Europe is the only region so far where peace agreement amnesty provisions containing language barring amnesties being granted for international crimes has been greater than the number of peace agreements that allowed amnesties for these crimes. However, I think we should bear in mind that for Europe, the numbers are relatively small in terms of the peace agreements that have amnesty provisions, and half of those relate to the conflict in the Balkans and were enacted after the International Criminal Tribunal for Yugoslavia had been established. So overall, 76% of the 117 peace agreements with amnesty provisions since 1990 to 2024 have had no exclusion for genocide, war crimes, and crimes against humanity. Again, this suggests that the anti-amnesty norm doesn't necessarily have widespread support among states, particularly not among those that are affected by conflict. The next data I'm looking at relates to the amnesty laws themselves, and this comes from my own Amnesties Conflict and Peace Agreement database. So here again, I've been looking at the language of the amnesty laws, and I code them as excluding international crimes where the laws have explicit language to that effect. It's much more difficult to code where an amnesty covers international crimes because states don't like to admit that. So only 2 amnesties where they'll actually say I'm granting amnesty for war crimes. Usually they prefer more ambiguous phrasing like all conflict-related offences or all political crimes. So to try and work out where amnesties cover international crimes, I've been relying on secondary sources that say this amnesty was extended to international crimes. So UN reports, case law, and reports of leading international NGOs like Amnesty International and Human Rights Watch. That data is limited. There's a lot of amnesties where there hasn't been extensive international scrutiny, and particularly when I'm looking at the earlier time periods in the 1990s. So I'm fairly confident that I am dramatically undercounting how many amnesties extended to international crimes. But so bear that in mind when you're looking at this data. But nonetheless, what you can see on the slide there is that across all world regions, the states have still been granting amnesties for international crimes. I think overall, from 1990 to 2023, I was able to find 92 amnesties that covered international crimes, and compared with 88 that explicitly excluded them. And if we look closely, I think by region, we can see that African and Asian states have been much more likely to grant broader amnesties for international crimes than states in other regions. So these are quite blunt figures that tell us very little about the domestic politics that gave rise to the particular amnesties. But I think, again, this data suggests that it doesn't show us that most states are willing to comply with a prohibition on amnesties for these crimes. So I'm coming now to the last slide of the data that I'm using for the book. So here I'm looking at third state signatures to peace agreements. So again, I'm relying on the data from PeaceRep. And I went through the 117 peace agreements with amnesty provisions and tried to identify where PeaceRep has data about third-party signatories. So what I mean by third-party signatories is other states or international organizations that have been willing to sign up to a peace agreement. Because peace agreements are obviously signed by the belligerent parties, but often they're signed by other actors. This may arise when those other actors have been involved in mediating the agreement, where the agreement contains obligations for them in respect to its implementation, or signing up could just be an expression of political support for the agreement. And so when I looked through this, I was able to find data relating to state third-party signatories for 79 peace agreements. And as the slide shows, I think there were 65 states were third-party signatories to 34 peace agreements relating to broad amnesties, with no exception for international crimes. But this compared to only 32 state signatories for 14 agreements that excluded international crimes. So again, states seem to be more likely to sign up to broader peace agreements, to endorse them, than to reject them. And if we look at the data by region, we can see that African states are the group of states most likely to sign up to peace agreements that exclude international crimes. But even in that region, more states have signed up to broad peace agreements. And then the last little bit of data that I'm going to show you relates to the Universal Periodic Review. So here I'm drawing on the UPR Info's database of state recommendations. And the UPR is a cyclical peer review process that's run by the UN's Human Rights Council, in which states make recommendations to other states on how to improve their human rights record. These recommendations aren't legally binding. Instead, they apply a form of political pressure to states. States usually receive about 200 recommendations each time they're reviewed. So there's quite a wealth of information that comes through this process. And when I first logged on to UPR Info's database, I could see that over the first 3 cycles, states had given each other collectively a total of 98,274 recommendations. So I approached this database with a great sense of trepidation, thinking I'm about to be deluged with all these recommendations relating to amnesties I have to work through. But when I searched for amnesty and amnesties, I only found 25 recommendations relating to amnesties. So there were hardly any. And these related only to 14 countries, because lots of states had made recommendations about to Uruguay and Chile, asking them to amend or remove the amnesties they had related to the military dictatorships. Of the recommendations that were made, 6 were made by states in the Americas, 11 by European states, and 1 by an Asian state. So these are very low numbers of recommendations calling on states to refrain from or annul amnesties for international crimes and serious human rights violations. And so again, it shows that states have been quite silent on this issue. There could be multiple reasons for this. So it could tell us that states don't view the anti-amnesty norm as legally binding. Or it could mean that they're reluctant to make recommendations that they think states will not be able to comply with, or that may be politically destabilizing in those contexts. However, as with the other sections, I think this data, again, says there is evidence that widespread state acceptance of a prohibition on amnesties is lacking. So, coming to the conclusion now. So cumulatively, I think the data I've explored here suggests that there's insufficient state practice and opinio juris to confirm the existence of a rule of customary international law that prohibits amnesties for international crimes. Instead, there's been sustained resistance and contrary practice to such a rule, and widespread state acceptance of this, seemingly, from other states. As such, I think the data supports the observation of the International Criminal Court, the Appeals Chamber, that international law on amnesties remains uncertain or still developing. For some, these findings may be a cause of concern. They may be viewed as undermining the progress that's been made in developing an international legal framework to combat impunity. And they could be seen as potentially opening the door to allow human rights violators to grant themselves immunity from prosecution. However, I think there's reasons to view these findings as an opportunity. First, I think it's increasingly acknowledged that the legal developments in the fight against impunity haven't been matched by developments on the ground. In 2012, the then UN Secretary General, to quite great fanfare at the review conference, the International Criminal Court, proclaimed that the world had entered a new age of accountability. But just a few months ago, the current UN Secretary General said to the General Assembly that we're now in a world of impunity, where violations and abuses threaten the very foundation of international law and the UN Charter. Where such impunity is characterised by a disregard for law and an unchecked exercise of aggressive power, it is of course abhorrent. However, my research has long asked whether amnesties should always be regarded as a form of unrestrained impunity. Where an abusive regime grants broad, unconditional amnesties to benefit its leaders and its supporters, such characterizations are, of course, wholly appropriate. However, as the Belfast Guidelines on Amnesty and Accountability explored, amnesties that are produced through negotiations that seek to balance flexibility on criminal sanctions with measures to fulfil victims' rights to peace, truth, justice, and reparations may have results that undermine impunity in different ways depending on how those laws are adopted, designed, and implemented. Secondly, I think acknowledging that customary international law does not have an established rule prohibiting states from granting amnesties may be important for reducing the obstacles to resolving armed conflicts. Today, the UN says we have the highest rate of armed conflicts in the world since the end of the Second World War. In addition, peace mediators are saying that it's increasingly difficult to reach comprehensive peace settlements to armed conflicts. Assertions of a customary international law rule that prohibits amnesties risk placing yet another obstacle in the way of political settlements. And I think this is particularly clear when we look at the growing body of literature measuring the impact of amnesties on peace. So there's one piece that I think questions this a little bit that I'll talk about first, and then I'll talk about the more positive findings. So one political scientist, who's my friend, Jeff Dancy, found in 2018 that in general, amnesties embedded in peace agreements are associated with long periods of peace. However, his is the only study so far to then separate out and try and measure separately the consequences of amnesties for international crimes. And he observed for those that amnesties for serious violations do not result in longer lasting peace than contexts where no amnesty was used. However, his findings do not state that amnesties for international crimes result in worse outcomes than if no amnesties were granted. And of course, this is the only study so far to look at this. And I think it needs to be considered alongside the other literature that's been looking at the impacts of amnesties on peace and to assert much more positive outcomes. So, for example, Mallinder found that the inclusion of amnesty provisions in peace agreements significantly reduces the risk that peace agreements will fail. Reiter observed that 26 amnesties resulting from comprehensive peace agreements all led to a permanently terminated conflict and lasting peace between the parties. Loyal and Apple found that a government that implements amnesties is 35% less likely to fall back into conflict. Daniel found that amnesties granted during a negotiation process can support conflict termination. And Cho argued that amnesty meaningfully reduces the risk of repeated civil wars when accompanied by power-sharing agreements. And a forthcoming study by Dancy and Tom found that, compared with criminal trials, amnesties are correlated with fewer restrictions on freedom of association, lower levels of political polarization, and lower levels of anti-democratic movements. So if these findings are accurate, restricting states' abilities to grant amnesties could inhibit peace building. So the challenges the world faces today, as we all know only too well, are profound and serious. To me, they suggest we're not in an opportune moment to progressively develop international law. Instead, there's an urgent need to understand what the existing international law requires of states and to encourage them to work within that framework to deliver peace. If amnesties are one means to achieve this, then the findings I presented tonight should hopefully be useful in clarifying the legality of this aspect of conflict resolution. Thank you.